And it's my pleasure to open this conference, the first virtual CIS arbitration conference, where we will discuss a range of issues related to CIS dispute resolution, including treaties, sanctions, compliance, enforcement. The conference will last for 2 half days. So we have a session today from 9 a.m. until 1:15 UK time, and tomorrow during also the morning we'll have a morning session. It's morning here in London, but it's not morning in some other places where our participants come from. My name is Yarik Kryvoi. I am the founder and co-director of CIS Arbitration Forum, and I'm also senior fellow at the British Institute of International and Comparative Law, working primarily on dispute resolution issues. We were planning to organize an event to bring together those people who write for the CIS Arbitration Forum website, those who read it for quite a while. But it's putting together an event is a difficult logistical exercise, and making it in the virtual format actually made it easier. So it's the first event, but definitely not the last one. And the beauty of virtual events is that we can have speakers from different jurisdictions who don't have to fly, pay for their hotel, and still we can benefit from their wisdom, from their experience. So today we have around 75 participants registered for this event. Roughly half of them are in-house lawyers. We have also a few people working for the government, and the rest are private practitioners based either in the CIS region or in Western Europe, although we also have people from Japan and from other jurisdictions. We will record this conference, and more specifically the presentations. We will not record the Q&A session to make our discussions as candid as possible. We haven't yet decided what to do with those recordings, but if you have any issues with us recording your presentations, please let us know. We are also open to your ideas for future conferences, for cooperation on other projects. So just get in touch either with me, I'm based in London, or with Dmitry, who is based in Moscow. Very eager to hear from you. We'll also publish the slides of PowerPoint presentations, as well as the keynotes addresses of Baiju, maybe also of the second keynote address, so that people can access them later as well. We are also happy to thank Carrie Olsen as the sponsor of this conference for supporting it, and we will have a speaker from this firm tomorrow as well. Most presentations will last between 10 and 15 minutes, except for our keynote addresses, and we hope that there will be enough time for Q&As, for questions, and you can ask your questions either using the chat box or just raising your hand, your virtual hand during the Q&A session, and then we'll let you ask your question. We also encourage, where possible, to keep streaming your video, because that contributes to a better real experience, but obviously you don't have to do it. It's entirely up to you. With this, let me pass the floor to Dmitry, who will say a few words, and then I will introduce our keynote speaker. Dmitry, over to you.
Dear colleagues, I'm very glad to greet you on behalf of CIS Arbitration Forum, which is a platform and a think tank in uniting people close to the region. Myself, I am director of CIS Arbitration Forum, also associate professor of Moscow State Institute of International Relations, and as well of Higher School of Economics, and a Russian legal practitioner. Well, it happens so that all of us are closely connected with this part of the world. Either we were born here, or were educated here, become lawyers, or anyway, our professional and often private life is closely connected with this region, which is really manifold. and combines Eastern and Western legal and business cultural traditions. As you know, disputes with CIS-related parties constitute a large part of caseload of major arbitration centers and of state courts of international. These disputes are really often significant in terms of value at stake. So this region is also turbulent as regards legislative reforms. And for more than 10 years already, CIS Arbitration Forum covers international dispute resolution issues and developments related to this region. The particular feature of CIS Arbitration Forum compared to other similar platforms and resources, web resources, is that it has free access. All publications on our website are free and people can get opportunity to read them. Our readers and also our contributing authors include legal practitioners and academics from major part of the world. There are already more than 500 analytical posts published on our website, and they always include a rigorous legal analysis. They are professional and thoughtful. As a result, our posts are cited sometimes in thick books, legal treaties. They are from time to time republished in LexisNexis database, and even some posts are mentioned in UNCTAD reports. Apart from such posts, our activity includes preparing academic articles. Even one of them was referred to by U.S. Court of Appeal in a case related to enforcement of arbitration award. And also we have a pool of experts from all jurisdictions of CIS and close countries, so to prepare legal opinions on the law of these countries, also comparative legal researchers. And we encourage you, therefore, to become or to remain our contributing authors. In particular, I think, and definitely this conference will become thought-provoking and result in the opportunity to look at this international dispute resolution from new perspectives. That said, we wish all attendees to obtain great intellectual satisfaction from the discussions of today and tomorrow. And please do not hesitate to actively participate, to ask questions, to make comments to each other, to share your experience. So let this conference begin.
Thank you very much, Dmitry, for this overview of CIS Arbitration Forum. And now it's my pleasure to introduce Baiju Vasani, who is our keynote speaker. Baiju is a partner at Ivanyan and Partners, in charge of the international dispute resolution practice. And I've known Baiju for many years. Initially, we met when he was working for another law firm, and we worked within the framework of the Investment Treaty Forum, which I run at the British Institute of International and Comparative Law. And I think Baiju will be an excellent person to discuss what makes disputes related to the CIS region different compared to disputes from other parts of the world. And he will also share some of his own personal impressions of working in this region. And Baiju will be happy to take questions if there will be any questions at the end. Baiju, over to you.
Thank you, Yarik. Thank you to the organizers for this invitation. It's a great honor to provide the first keynote of this event. Now, I know many of you, and it's good to see old friends among the participants, but there may be some of you who don't know me and are thinking, what is this British Indian doing talking about what makes CIS disputes different? Well, my Russian language is rudimentary, and as Dmitry said, many of you are schooled in the CIS region. I am not, but for better or for worse, for the last 15 years, I have been involved in many disputes in the CIS region. And Professor Kryvoi said, well, why don't you tally up what you've actually done? And when I did, it surprised even me. I have in the ISDS field done now 7 proceedings against Kazakhstan, 3 against Uzbekistan, 2 against Latvia, 1 each against Belarus and Lithuania. I've represented claimants from Kazakhstan, Ukraine, Russia, Kyrgyzstan, and Estonia. I've represented the Kyrgyz Republic in 3 matters, and currently I am one of the lead counsel for the Russian Federation in its Crimean related arbitrations. And those are the ISDS. In addition to that, I have done commercial cases and have acted as arbitrator for both ISDS and commercial cases. So being someone who has some experience over the last, let's say, decade and a half in this area, what Professor Kryvoi said was, well, look, Baiju, you're in some sense an outsider looking at this region. Do you see any discernible patterns among the disputes in the region that you could say, look, this makes it different? What I decided to do was to look at ISDS cases, and I hope you forgive me for doing that, but of course they are public, unlike commercial cases where things tend to be confidential. And as I was thinking about it, there were many things that I could have brought up. Some of this, in fact, you're going to speak about over the next 2 days. One being, for example, issues of treaty succession. I was lead counsel to both Worldwide Minerals and Gold Pool in this arena, and it's interesting. But I think we've probably just scratched the surface of what type of succession there is to the various states that were formed at the end of the Soviet Union, and I'm very interested in that particular panel, because I think there's more to come in that particular field. We also all know about the linguistic questions of treaty interpretation in some of the Central Asian cases, particularly, for example, the fork in the road provision in the Turkey BITs with regard to the need for domestic litigation. You also have many cases which talk about moral damages, where there's a question of whether, if the tribunal don't find questions of breach against the investment, whether they could nevertheless find breach of the treaty in relation to treatment against the investor. And of course, the interesting questions over country risk premiums as to whether, when one does a DCF analysis, one can add in the higher country risk premium with regard to prevalence of expropriation. But the truth is that many of those issues are not just unique to the CIS. You see them, for example, in former Yugoslavia, in Asia, and in Venezuela. So I wanted to take a more general approach and talk about 3 broader themes that I can at least discern that I think are relatively unique to the way business is done in the CIS and how governmental systems are set up in this region. And I think these 3 themes are at the root of many of the issues in CIS-related disputes. So let me start with the first, and that is what I see as the overlapping concentration of economic power, political power, and family ties. Now, what you tend to find is economic power is concentrated more than, let's say, in the quote-unquote West, in the hands of a few key players. Political power is more concentrated in the hands of a few key players. And it is not uncommon for there to be a direct overlap between those that hold economic and political power. When we talk about economic power, we all talk about the word oligarchs. And of course, there are specific individuals who tend to have their fingers in the many pies, and that tends to stem from the privatization of many of the state assets following the time of the breakup of the Soviet Union. And business, politics, and family tend to be highly interconnected. And indeed, one could say, well, an oligarch cannot get his or her, and it tends to be his, economic power without being politically connected, nor can that oligarch stay with his or her assets unless they are politically connected. And then what that tends to mean is, well, oligarchs themselves tend to become claimants when political relationships of theirs go south. So an oligarch can suddenly become an unpopular political figure. They may involve themselves in politics, and business deals then become tricky when that oligarch interferes in politics unnecessarily. A few examples. The Ukrainian oligarch Igor Kolomoisky is a frequent claimant in investor-state cases, of course, not necessarily directly, but he has beneficially owned various entities and indeed brought claims against his home state under the ECT. He's brought several claims against Russia with regard to investments originally located in Ukraine. And recently you will have seen that he has threatened cases against the United States. And of course, as an oligarch with various interests, there have been allegations against him with regard to Privatbank, and he is indeed a defendant in various lawsuits related to the matter. And what would be interesting in the case of Kolomoisky is how his fraudulent conduct, or allegedly fraudulent conduct, relates to his cases against various countries as a claimant. Similarly, you have the cases brought by the Hourani family, and I should say I was lawyer for the Hourani family for many years. The Houranis built a business empire in Kazakhstan that included things from poultry to oil to pharmaceuticals. And one of the accusations of Kazakhstan was that the manner in which the Houranis had built up their empire was because one of the Hourani brothers was married to the sister of the president's son-in-law, Rahat Aliyev. And at the time of the falling out of Rahat Aliyev and President Nazarbayev, their businesses were targeted, and that spawned a series of disputes. You see the same with the Stati family, the Stati brothers, where they allege that President Nazarbayev commenced a harassment campaign against their oil business in Kazakhstan as a favor to the then president of Moldova. And they alleged that part of the harassment was for them to fire sale their investments to a different Nazarbayev son-in-law. You see the daughter of the former president of Uzbekistan, Gulnora Karimova, who once was venerated and had powerful interests all over the region and all over the world, and then ended up isolated and in jail. And when she became in political exile, you saw investigations of people who were once close to her and had done business to her. So what you tend to see is that politics in the region at the very top tend to be relatively stable. Underneath that stable surface is a whole current of volatility, and you find investors who get caught up in those changing tides. And I would say that is unique difference number one. The second one I want to talk about is what I see as the delta between what an investment tribunal, or what a Western-minded investment tribunal tends to want to see in terms of how business is done, and the reality of how business is done on the ground. And what I tend to see is that on paper, laws, regulations in CIS nations are strong. They are absolutely watertight, and they are exactly following along with a quote-unquote Western standards. But then what you see is the reality on the ground tends to be very different from what is on paper. Let me give again some examples. Ownership of an asset is normally, should be straightforward in terms of legal title. Here in the CIS, you tend to see a lot of beneficial ownership, multiple levels of holding companies, proxy officers, proxy directors, and even secret or bare trusts, as we would have under the common law. You also see a difference between how states have their laws on paper and how they are then applied in reality. And you often have layers and layers of bureaucracy on paper as to every sign-off required at different levels. But when you actually look at the transactions that occur, you see that some of those transactions don't occur with the same strict requirements. Not all the transactions have the technically required government approval. Regulators don't often cross every T and dot every I until something catches their attention. And these types of differences, that disparate nature between the paper reality and the actual reality, creates a lot of questions for tribunals. And we see, for example, in the Kim versus Uzbekistan case, again, that was one where I represented the claimant. And the question was, does one have to follow every single law or regulation, or is it a question of proportionality and a balancing test when one comes to the question of legality? What do you do when CIS law has a difference between a null transaction, a void ab initio transaction, avoidable transaction, an illegal transaction? Is there a difference in how international law should treat that transaction depending on the various levels through which CIS law looks at those particular transactions under the relevant civil code? What about, for example, as in UCOS, you have non-compliance with the claimant itself, because there are serious questions of contributory fault, and how does one balance the act of the state versus the acts of the investor? Does, for example, you see this in the Bellicon case, how does inconsistent application of regulation evidence bad intent on the state, on the part of the state, and defeat a police powers defense? And so what you see time and again is strong law on paper. And then when it comes to application, there tends to be a lot to be desired. And that can lead to both illegality, accusations against the investor, and then accusations that the state was laissez-faire until its interests were not. And the question with the tribunal is, do you go with custom or how things are done on the ground, or does one look at the law itself and say, well, that's what the law was, and that wasn't met? Similar to that, and I think one of the areas where this has been explored most is allegations of corruption. And I think this is the reason corruption allegations are so easily raised in CIS cases. And you see this time and again. And it's fairly common, particularly for cases, let's say 10 years ago, certainly 20 years ago, that are still in dispute now, where an investor would always have their man on the ground. Yes, the person who would help them navigate, the agent who would help them for a stake in the equity, or under a services contract, who would help them deal with the political environment. Another question is always how the purchase price can be paid outside of the country. So often you find a sale of an asset in a CIS country between a buyer and seller, but the purchase price is paid between, let's say, a Cypriot entity and a Hong Kong entity. And the question then becomes, does this outside transaction, with the use of an agent on the ground, with very loose, vague services contract provisions, does this mean that the deal was corrupt? What information do you need? And it's very interesting, for example, when you look at Uzbekistan, to compare the Metaltech and the Kim cases, where in one it was an indicia of corruption, and in the other, the tribunal found that the consulting payments were a legitimate finder's fee to a genuine businessman. You also find questions about what is the market value of the asset, and is there a difference between the amount paid and the asset? And the question is that differential a bribe or some issue of corruption? And the question is, well, where does that extra money go? And the question is, well, does it go to someone who has governmental authority, who has the ability to control the transaction? So in Stan's Energy, there was no bribery or corruption because the claimants had no reason to believe that the minister's request was illegal. In Kim versus Uzbekistan, again, Uzbekistan were not able to show that Gulnara Karimova was a government official at the time there was this alleged excess payment. So I think there's a very interesting point between this delta of the paper laws and how business is actually conducted, and this and the actions within that delta, and whether one can say that that leads to allegations of corruption or illegality. The last general theme that I wanted to discuss, and this one I think has many offshoots, but it is how, at least in the eyes of an external observer, the executive, legislative, law enforcement, and judicial organs of CIS governments are, rightly or wrongly, seen as more influenced and more interconnected with each other than they are in a Western ideal. For centuries, the Western ideal was the question of checks and balances. So the idea was that no particular function of state between the judiciary, the legislature, and the executive had any particular power or authority over the other. Each one was able to control the power so that none would become too powerful. And it seemed that the allegation against certain CIS states is that that check, those separation of powers, are less obvious. Now, an interesting question, and I want to come back to this at the end because it's given me idea for a PhD. If you see me disappear to do a PhD, you know what I've gone to do. But I'm interested to know especially from you who are scholars of the Soviet Union style, whether this notion of the interconnected unitary government and the legacy stems from the one-party Soviet framework. Does that legacy still hold for CIS states in the sense of you have less of a history of the separation of powers and the checks and balances that one would have in a common law system? And we see this interplay, as I've said, of state organs in allegations in CIS cases. For example, you often find the question of a creeping expropriation or creeping fair and equitable treatment allegation. And claimants often say, well, I had a falling out with the executive, and then this happened, this happened, this happened, this happened, as if there is one entire conspiracy between all aspects of the state. And the defense is, as I have done, and I've argued the other side as well, well, you know, that's a big claim to say that what is on paper, a very separate function of judiciary, a very separate function of legislature, to say that, well, one person gave the word and at the stroke of the pen or at the click of the finger, all these various unseen hands started to act in unison to separate the investor from its investment. But this has been alleged, and in some cases it has been upheld. You look at, for example, the Stati case. And what the claimant said in that particular case was that Kazakhstan employed what is called a playbook. And this comes from American football, which is the one sport I actually quite like from my time in the United States, where you see the coach, and the coach has a piece of paper with all these various things. So we're going to run this play. This is the one we're going to run on this 3rd down and 3. And what the investors have alleged, and other investors have alleged, is that there is a playbook where it starts out with a dispute with the executive, often those in political power, sometimes with regard to family. And then that leads to other executive agents, sometimes the judiciary, as I'll come on to, who are able to work in unison to separate the investor from their investment. And it is a coordinated effort involving tax authorities, financial police, judicial system, the prosecutor, harassing, fines, etc., etc. And you saw that also in the Rumeli case, where Rumeli said, well, Kazakhstan had engaged in a series of acts over a period of time, which culminated in the expropriation of their property. Now, there's a few aspects of these areas that I wanted to touch on that I thought were interesting. One I already alluded to, which is, well, how does the tribunal treat a case where, in fact, for example, if there are allegations of tax, use of disproportionate tax assessment, as there were in UCOS, where the claimants themselves are found to have purposely circumvented their tax obligations? The question of how does one deal with contributory fault in those cases? The second thing that I find very interesting is criminal law. And I actually gave a talk at one of the ITF forums, which is the availability of provisional measures at ICSID when it comes to criminal allegations. And the answer is it's not easy for a claimant to get provisional measures in criminal law cases. You see this, for example, in the Karatube cases, where the Harani family claimed that there was harassment of criminal cases of an alleged murder allegation in Lebanon, that Kazakhstan were harassing the claimants, and all attempts at interim or provisional measures before the tribunal failed because tribunals are not keen on involving themselves in the sovereign prerogative of a state enforcing its criminal law. So it's very interesting how a state is able to use the criminal law as a way of almost immunizing itself from scrutiny by tribunals, and yet to gather evidence to potentially harass claimants, or, seeing it from the state's point of view, to genuinely prosecute its criminal laws as it has a sovereign right to do. It depends from which point of view one sees this question. 3, you often see allegations that the prosecutor, who is genuinely part of the executive rather than part of the judiciary, but has a very close relationship with the judiciary and acts as the bridge between the executive and the judiciary. And then finally, which I think is going to be more and more interesting, and there are cases right now that are ongoing. You've got, for example, Big Sky versus Kazakhstan, a case I was initially involved in. But you're going to get cases that question the role of the judiciary. And traditionally, from an international perspective, tribunals have been quite careful to tread on the toes of the domestic judiciary. And the question is, well, to what extent does an act of the judiciary breach a BIT? Is it only denial of justice? Or is there a lower standard under FET, some sort of gross impropriety? Is there such a thing as judicial expropriation? Do you need an act of the executive in addition to the judiciary in order to meet the standard of breach? And if you just look at the cases of System, Guarantee Koza, Rumeli, and as I said, others coming up, you'll see that this is a question that has not many good answers at the moment. and indeed, I think Romelli is very interesting because you saw what the tribunal said there, that there was improper collusion between the Kazakhstan State Investment Committee and claimant's business partners, which then led to a separation of the investor from their assets through the courts. And here again, you see the courts potentially being used by other private entities who are deemed, I think, in the region as corporate raiders. And the question is, even without executive function, is it enough that the judiciary has been used for corporate raiding? So in the last couple of minutes, let me sum up, and that will leave us with a couple of minutes for question and answers, if there are any. But much of what I've said is also prevalent in other regions. It's not that, for example, you don't see these questions of judicial expropriation elsewhere. You see that in, for example, Chevron, Ecuador. It's not as if you don't see the question of criminal allegations and how that works. You see that many times in, for example, Latin America and Africa. But I think what is significant, if one were to look at a pattern of the CIS cases as a whole, is just how often the same issues arise in nearly every case. And it's also interesting how each of these issues appear together in so many particular cases. And what else is interesting is how one can almost swap out the state, one state for another, and the acts of that state are almost quite similar. It's as if the playbook, so to speak, is well known through the region, and the acts of the claimants, the illegal acts of the claimants, is also very common amongst them in the way they act. And this leads to my PhD question, which is it a question of history? Is it a question of legacy of Soviet times? Are we seeing how the Soviet Union used to work, that while we are more than 30 years from the breakup of that country, are we still seeing some of the legacy living in how governments are acting, the way in which industry was broken up and privatized, the way in which people made their billions in the early 90s, the integration of economy and politics even today, and how the history of that political science can help us navigate and understand how disputes of the region today could be and should be resolved. So hopefully I've given you some food for thought. I'm welcome, please, I'm happy to answer any questions, but otherwise, Professor Kryvoi, I will leave it at that and pass the floor back to you.
Thank you very much, Baiju, for this very interesting overview of similarities between various CIS jurisdictions. And I was wondering, you spoke about history quite a lot and the implications of various Soviet practices. I was wondering whether you can see that different jurisdictions sort of are now more apart than they were, let's say, 10 years ago or 20 years ago. So let's say if you compare Turkmenistan and Ukraine, these are completely different political systems, economic systems. Russia is, is unique in its own way. Can you say a few words on sort of legal systems and dispute resolution, different countries?
Yeah, I think that one's interesting, Professor Kryvoi, because I think certainly over the last 30 years, what you've had is, I think there's a few things to again, in the history. I think one is how integrated the country was to the Soviet Union and how it felt outside of the Soviet Union. Yes. So, for example, you've got the Baltic region, which is very different, for example, than let's say Russia and Ukraine. I think the second thing that's very interesting is just how far each country, following the breakup of the Soviet Union, looked west and sought to emulate the European Union or even the United States, or how it looked towards Russia as sort of the mothership, so to speak, as it was at the time, and continue to emulate the legacy that it has. And I think what you tend to see then is on paper, certainly on paper, a move between those that have sought actually coming into NATO, coming into the EU, who've sought to move their legislation, their government, their style. I mean, from how the electricity is run to how the legislature is done, how judiciary are picked, all these various things, and they've tried to shift it towards the West, and others have less so done that. Now, I would still go back to, though, Professor Kryvoi, that although you see the paper shift, that doesn't necessarily mean that one has the actual shift on the ground. So sometimes one sees that, and maybe the delta there is bigger between how laws are on paper versus how business is actually conducted. And many times businesses is still conducted as it was, even though the laws now are reflective of a Western ideal. And there, in fact, it becomes even more disparate between how business is done and how businesses should be done on paper.